Friends, now we are going to discuss important multiple choice questions with explanation on the Companies Act 2013, specifically related to the formation and incorporation of a company. So let us start with first question, and it asks which of the following is are the stages or stage in the incorporation of a company, and options are promotion, registration, capital raising, all of these. See friends, promotion is the first stage in the incorporation of company. After the promotion, the registration processes begin, and after the registration of the company, the capital raising stage starts. So all of the first option, that is promotion, registration, and capital raising, are related to the or are the stages in the incorporation of the company. So here option D is the right answer. Let us move on the next question, and it asks us which section of the Companies Act 2013 gives requirements related to the formation of a company. See friends, this question is about the section of the Companies Act 2013. So as we have already discussed in previous question that there are 470 sections in the Companies Act 2013, and this question particularly asks us about the uh, section which gives requirements related to the formation of a company, and option are section 2, section 3, section 4 and 5. See friends, we have already discussed in previous video that section 2 is related to the definitions, various definitions given in the Companies Act, right? So you have to memorize this, that in section 2 only definitions are given. And see, this section 3, this section 3 is related to the formation of company. So for this question, option B is the right answer, because section 3 of the Companies Act 2013 gives requirements related to the formation of company. So here option B is the right answer, right? Let us move on the next question, and it asks the Companies Act 2013 contains just dash chapters. So see friends, as we have already discussed that there are 470 sections in the Companies Act, and there are 29 chapters. See, in order to group or classify the various sections, these chapters are created basically, right? So here in Companies Act 2013 there are 29 chapters. So here option B is the right answer. Let us move on the next question, and it says is a discovery of business opportunity and bring it into reality. So options are formation, registration, promotion, or capital raising. See friends, discovery of business opportunity or idea, it is related to the promotion. So here option C is the right answer. That is, promotion is a discovery of business opportunity and bring it into reality. So at the stage of promotion, the idea about the formation of company generated, and the promoter tries to bring it into reality, right? So here option C is the right answer. Let us move on the next question, and it says the term promoter is defined under section dash of the Companies Act 2013. So this question is about the definition of promoter. So as we have already discussed that the all the definitions of the Companies Act are given in the section 2, right? But here see, options are related to section 2 only, but there are under sections. So we know that section 2 under section 20 gives definition of the company, right? And this question asks us about the term promoter is defined. See friends, here it is necessary to memorize the important sections of the Companies Act, right? Like the definition of company is given in the section 2 uh, under section 20, right? And the term promoter is defined under the section 2 in section 2 under section 69. So here option D is the right answer, right? For this question, the term promoter is defined under section 269 of the Companies Act 2013, right? Let us move on the next question, and it says the is a person or group of person who takes initiative in the formation of company. So see, if you read this sentence carefully, you will find that the sentence asks about a person or group of person who takes initiative in the formation of company. So we know that promoters are the persons or group of persons who take initiative in the formation of a company. So here option A, that is promoter, is the right answer for this question. Let us move on the next question, and it asks us which of the following is the first step in the promotion of a company, right? So here we have discussed a lot about the stage of promotion. Now the question is on the steps in the promotion of the company, and options are planning of registration, investigation of the practicability of the idea, discovery of an idea, and approval of the name of the company. These are the options. See friends, the question asks us about the first step in the formation promotion of company, the first step in the promotion of the company. So see, the promotion, yeah, the first step in the promotion of the company is an discovery of an idea. When the idea comes into the mind of the promoter, then he tries to investigate the practicability of the idea. Then this investigation of the practicability of the idea is second step, right? First step is discovery of an idea, second step is investigation of the practicability of the idea, then third step is planning of the registration, then approval of the name of the company. So all these steps follow later. So here the question asks us about the first step in the promotion of a company, and first step in the promotion of company is discovery of an idea. So here option C is the right answer. Let us move on the next question, and it says the promoter of the company stands in dash capacity. So here the question is on the promoter's capacity, whether the promoter is an agent, trustee, or agent, or he is in a fiduciary position. So see, friends, the position of the promoter in the company is generally fiduciary in nature, because before the incorporation of the company, promoters look after all the matters related to the registration of the company, and because of that, the position or his capacity in the company is generally as of the capital as considered as the fiduciary in nature. Fiduciary means trust and confidence. Fiduciary in nature means related to trust and confidence, right? So here option D is the right answer. Let us move on the next question, and it says is a process which create artificial person or corporate body. So see friends, we know that artificial person is created after the registration. So here promotion, incorporation, director, and subscription are the options. So option B, that is incorporation, or it is same as registration. So incorporation is a process which creates artificial person. So here option B is the right answer. Let us move on the next question, and it says is a process for reserving a name for a new company on MCA portal. See friend, this question is related to the registration of company on the MCA portal. MCA stands for Ministry of Corporate Affairs. See this, the full form of MCA can be asked in the MCQ question, that what is the full form of MCA. So friends, MCA stands for Ministry of Corporate Affairs, and Ministry of Corporate Affairs of Central Government of India has developed a portal on which we can start the registration process of company in online mode, right? So this question asks us about the process for reserving name for a new company, right? So we know that to register a company we have to fix the name, right? And for that purpose there is a system on MCA portal where you can reserve a name for a new company, and this question is about that. See friends, this process is known as run. So here option C is the right answer. In next question we are going to see what is the full form of this process. So here run is a process for reserving a name for a new company on MCA portal, right? So here option C is the right answer. Let's move on the next question, and as I said, this question is related to the full form of run, service of MCA. So it is friends, see, this is basically reserve unique name. This is the process or system on the MCA portal which is used to reserve a unique name for the company, right? So here option A is the right answer. Let us move on the next question, and it asks us about the full form of CIN, and options are central identification number, corporate identification, current liability. See friends, this is direct question and the full form of CIN is corporate identification number. So here option B is the right answer. Let us move on the next question, and next question says zero registration fees is charged by MCA, that is Ministry of Corporate Affairs, for small companies with authorized capital up to. So this question says that MCA charge zero fees for small companies whose capital, authorized capital, is up to. So this is about the threshold limit above which there is a registration fee, and below that there is no registration fee. Options are 10 lakh, 15 lakh, 20 lakh and 30 lakh. See friends, this limit is of the 15 lakh. If the authorized capital of a small company is less than 15 lakh or up to 15 lakh, in that case Ministry of Corporate Affairs does not charge any fee for the registration purpose. There is zero registration fee. So here option B is the right answer. Next question asks us the term securities includes, and options are shares, debentures, bonds. So see, we are familiar with this term, that securities, and it is used commonly for shares, debentures and bonds in the company law and in commerce. So here option D, that is all of the above, is the answer for this question. Let us move on the next question friends, and next question asks us which of the following is or are the modes of raising share capital. So we have to mention the modes of raising share capital, which is the mode. So we know that private placement of shares is the one of the mode of raising share capital. In private placement of shares, the shares of company are allotted to a selected number of people, or those selected number of people are generally the close friends or relatives. And this private placement of shares is done without publishing the prospectus. Both private companies and public limited company can raise their capital through private placement of shares. So this is one of the mode of raising share capital. Next option is public issue of shares. Yes, company can raise uh, share capital by issuing shares, but only public limited company can issue its shares to the general public. Private limited company cannot issue its shares to the general public, right? So the second option, that is public issue of shares, it is one of the modes of raising share capital. Next, then third option, that is C, right issue of shares. Yes, a company can raise capital through right issue, where the shares are offered or issued to the existing shareholder, right? So here basically all of these three are the modes of raising of share capital. So here option D is the right answer. Let us move on the next question, and it says the amount payable on application of security shall not be less than dash percent of the nominal value. See friends, this question is related to application money. We know that when company offers or issues its shares to general public, it does not receive whole amount of shares in one time. Generally it receives amount in installments, like some amount is received on application, some amount is received on allotment of shares, then first call, second call and final call. In this way company receives amount in installments, right? So this question asks that amount payable on application of security. So as we have discussed that this term security includes shares, debentures, bonds and mutual fund or exchange traded funds also. So if company issues shares or debentures, then minimum application money should be what? So security shall not be less than. So this is about the minimum application money, and friends, this minimum application money is 5% of the nominal value of the security. So here option B is the right answer. It means when company issues its shares to general public, at least 5% of the nominal value of shares or debentures should be received as a application money. Let us take an example here. Suppose the face value or nominal value of a share of company is 100 rupees. In that case, company should receive at least rupees 5 as a application money. This is minimum. Company cannot receive 4 rupees as a application money if the face value is 100 rupees, right? Company can receive 10 rupees, but minimum amount is 5% of the nominal value of security. So here option B is the right answer. Let us move on the next question, and it says can raise capital by issuing a prospectus to public. So here we have discussed already that only public company can raise capital by issuing a prospectus to public, right? Private company cannot issue prospectus and appeal general public for the subscription of shares. Only public company. So here option D is the right answer. Subsidiary company, if it is a public limited company, then subsidiary company can offer, but uh, there is a possibility that subsidiary company can be a private limited company, right? Same thing is with the foreign company. So here option B is the right answer. Next question asks us, if company fails to receive the amount of minimum subscription as stated in the prospectus within dash days, it needs to refund the application money. See friends, this question is related to the issue of shares. When company issues its shares to general public, company mentions the amount of minimum subscription in the prospectus, and generally minimum amount of minimum subscription is 90% of the issue. It means company has issued suppose 1000 shares, then company should at least received application for 900 shares, then only company can allot the shares. That is the minimum subscription limit. Okay, this sentence or this question asks us, if company fails to receive that amount of minimum subscription as stated in the prospectus within dash days. So company has to receive this amount of minimum subscription within 30 days. Right. So here option C is the right answer. If company fails to receive the amount of minimum subscription within 30 days, then it needs to refund the application money to the applicants, right? So for this question, option C is the right answer. Let us move on the next question, and next question says only public company can issue dash to appeal general public for subscription of shares. So we have discussed that only public company can issue prospectus. So here option C is the right answer. Next question says both public and private companies can raise capital by dash of shares. So we have discussed this as well, that both public and private company can raise capital by private placement of shares. We have discussed that only public limited company can issue its shares to public. So public issue is for public company, and private placement is for both private companies and public limited company. So here option B is the right answer. Next question says which of the following company is not listed on the stock exchange. So we know that public company is listed on the stock exchange, but private limited company or private company is not listed on the stock exchange because the shares of private limited company are not transferable. They are not freely transferable, right? So here option B is the right answer. Let us move on the next question, and it is about the one person company, that is OPC can be incorporated by. So we know that one person company can be incorporated by only natural person. So here option C is the right answer. Next question asks us power of Securities and Exchange Board to regulate issue and transfer of securities is deal under which of the following section of the Companies Act, and those powers are deal under section 24. So here option B is the right answer, right? Friends, here I would like to show you the exact document of the Companies Act. So see here on the screen, you can see this is the document, the Companies Act 2013. This is the document of the Companies Act published by the government, right? So here, see, the Companies Act arrangement of sections. So as we have already discussed that there are 29 chapters. So first chapter is related to the preliminary, which includes short title and definitions. Okay, so in first chapter there are two sections. Then second chapter is about incorporation of company and matters incidental there too. So the question sections 3 to 22 are related to this incorporation of company and matters, right? Then in chapter 3, prospectus and allotment of shares. So these further sections are related to that, right? Then part the private placement part 2 is related to that previous chapter only. Then there is a fourth chapter which is related to share capital and debentures, right? So see friends, here basically I am trying to show you how the Companies Act they is exactly, right? So as there are 29 chapters and 470 sections, right? So here let me show you. So here chapter 20, which includes winding, well, section related to winding. So section 270 is related to winding up of the company, right? So see, in this way, the act has been divided into 29 chapters and 470 sections. And in addition to that, there are seven schedules to the Companies Act, right? And now see, friends, as we discussed that this chapter 1 is related to preliminary, and the section 1 is related to short title, extent, commencement and application. Then section 1 under section 1 is related to something, then section 1 under section 2 it extends to the whole of India, it is about the applicability, right? In this way. And the very important section of the Companies Act, that is about the definitions. So here section 2 gives the definitions about the various words and terms used in the Companies Act. So as I have already mentioned during the discussions that there are more than 50 subsections under the section 2. Like for section 2 under section 1 defines abbreviated prospectus, right? And we know that section 220, let me show you here. See, this section 220 defines the term company, right? In this way, we have discussed that section 24, company secretary, and all these things are related to the sections, subsections, sections, and subsections. So we have discussed one more section now related to the definition related to the promotion. It is section 2 under section 69, right? So let me show you here. Just have some patience. See, so section 2 subsection 69 defines the term promoter, right? So in this way, the whole Companies Act is divided into the various chapters and sections, right? And here we were discussing this because here the question was related to the power of SEBI, Securities Exchange Board of India, to regulate the issue, are given in the section 24, right? Then next question is about the which of the following section of the Companies Act 2013 mentions about the voting rights of the member. This is also one of the important section that that is about the voting rights of the member, and this section is section 47 of the Companies Act. So here option D is the right answer. Let us move on the next question, and it asks shareholder are the real owner of a joint stock company, right? So here option B is the right answer. Next question is related board of directors look after the management of the company. So here option A is the right answer. Then let us move on the next question. Next question says the initial investment made by dash in his business is known as. So initial investment made by owner in business is known as capital. Next question is about registered capital is also known as. Options are issued, subscribed. So authorized capital. Authorized capital is also known as registered capital. So here option C is the right answer. Next question says is a part of authorized capital which is offered for subscription. So we know that dash is a part of authorized which is offered, matlab it is issued capital basically. So here option D is the right answer. Next question says subscribed capital is the amount of capital for which company dash application from the investor. So subscribed capital is the amount of capital for which company has received. So here option C is the right answer. Right. Let us move on the next question, friends. I need to ask us reserve capital is the part of uncalled capital which company decides to keep aside and call at the time of dash only. So see, this is the reserve question related to reserve capital, and reserve capital as here said here that it is the part of uncalled capital, and that part that reserve capital is called only at the time of winding up of the company. So here option B is the right answer. Next question asks us dash are also known as ordinary shares. So we know that equity shares are also known as ordinary shares. So here option B is the right answer. Next question says which of the following is are not the modes of raising of share capital, and options are public issue, private placement, buyback, and all of them. So we know that buyback of shares is not the mode of raising share capital, right? So here option C is the right answer. Next question says public issue is the most common method of dash share capital. So public issue is the most common method of raising share capital, right? So here option A is the right answer. Friends, here I would like to stop. We will discuss the remaining questions in the next video. So now make sure that you have subscribed the channel and like, share this video. Thank you. Thanks for watching.